Subject: Law of Criminal Procedure. Topic: Framing the accusation, charge, and types of trials. Namaste and welcome back. Now, if you've been following our Explainer series, you know we've already covered the groundwork, right? We've gone from the initial FIR all the way through the very dynamic police investigation phase. Well, today we're hitting a really critical turning point. We are shifting from that evidence-gathering stage to the exact moment where the judge officially lays out the precise accusations. This right here, this is where the procedural machinery truly begins to turn.
In today's Explainer, we're going to be focusing on two key areas. First up is the charge, specifically its form, its contents, and alteration. And second, we'll dive into the types of trials, spanning across sessions, warrant, summons, and summary.
Section 1. The charge, form, contents, and alteration. Okay, so before a person can meaningfully defend themselves in a court of law, they need to know exactly what they are fighting against. Wouldn't you agree? So our roadmap for this section has two main objectives. First, we'll describe the specific requirements of a charge and exactly when those charges can be altered. And second, we want to contrast the trial procedures for sessions courts with magistrate-led warrant and summons trials. Let's get into it.
Let's first tackle the core concept here. What actually is a charge, and honestly, why does it matter so much? Well, at its core, it's a foundational concept defined to protect the balance of justice. I want you to imagine, just for a second, walking into a courtroom as an accused person. If the state simply handed you this massive, chaotic investigation file and just said, "Here, go ahead and defend yourself," that would be utterly chaotic, right? And deeply unfair. Framing the charge is essentially the judge stepping in to distill that entire sprawling investigation into a precise, formal accusation. It clearly states to the accused, on this specific date, at this exact time, you allegedly committed this specific act. It actively narrows the scope of the trial. Without it, the defense would literally be swinging in the dark, and that would fundamentally violate the presumption of innocence.
For example, when we look at the relevant provisions of the BNSS, we see that the procedural rights and duties are specifically designed to be clear and transparent. The absolute crucial point here is that a legal charge cannot be vague. It just can't. The BNSS explicitly mandates that the charge has to contain the specific name of the offense, the relevant section of the law, and all the necessary particulars required to give the accused crystal clear notice of what they're actually facing. But, what if a genuine error happens? The law does actually allow for the alteration of charges during the trial. But, and this is a big but, it's strictly on the condition that it does not prejudice the defense. This brilliantly illustrates how these procedural rules act as this powerful shield. They make sure the state's immense power is exercised with total clarity, essentially preventing any sort of unfair courtroom ambushes.
Section 2. Types of trials, sessions, warrant, summons, and summary.
So, once that formal charge is laid down, how does the trial actually play out in the real world? Well, the law is highly practical. It recognizes that a super complex murder case simply shouldn't follow the exact same track as, say, a minor public nuisance infraction. So we have varied tracks. We go from the rigorous sessions trials for the most severe crimes all the way down to rapid summary trials for petty offenses. But, and this is key, regardless of the track you're on, the underlying DNA remains incredibly consistent. It follows a three-step mechanism. Step 1 is initiating the mechanism. This is where the magistrate formally takes cognizance of the offense and presents the charge. Then Step 2 is validation and verification. Guys, this is the absolute heart of our adversarial system. The prosecution brings in their witnesses, they present the mandatory forensic evidence, and those audio-video recordings we examined in our previous explainers. And then the defense gets to fiercely cross-examine them. Finally, Step 3 brings closure. The judge weighs all that thoroughly tested evidence beyond a reasonable doubt and formally delivers an acquittal or a conviction. So you see, it's the exact same fundamental heartbeat, just operating at completely different speeds depending on the severity of the case.
Now, we definitely need to talk about a common pitfall here. A lot of students get tripped up by confusing the old CRA-PC provisions with the newly updated BNSS mandates. So if you're taking exams, make absolutely sure you are referencing the new section numbers. But honestly, this goes way beyond just memorizing new numbers to pass a test. The transition from the old procedural code to the BNSS represents a monumental shift in how justice is administered in our modern era. The machinery has been heavily upgraded. As we've seen, the BNSS integrates digital transparency directly into these trial processes. By seamlessly weaving electronic evidence into that crucial validation and verification step we just talked about, the updated mandates are creating a much more robust and accountable system. It is literally an entirely upgraded playing field, which is exactly why aligning your understanding with these new mandates is so absolutely essential.
All right, let's bring it all together. In summary, we reviewed the core elements of framing the accusation, the charge, and the types of trials. We mapped out the legal requirements, the practical application, and those all-important key safeguards. By crystallizing a raw accusation into a precise, formal charge, the court is guaranteeing that the accused knows exactly what they are fighting. And by channeling the case through the most appropriate trial type, whether that's sessions, warrant, summons, or summary, the system ensures that valuable judicial resources are used super efficiently, but without ever sacrificing fairness. These aren't just dry procedural checkboxes, okay? They are the living, breathing mechanics of constitutional justice working in real time to protect liberty. In our next explainer, we are going to continue this journey by exploring the very next phase of criminal procedure. But before we officially sign off, I want to leave you with a bit of a provocative thought to chew on. If the formal charge is the unshakable foundation of a fair trial, what actually happens when completely unexpected, game-changing evidence emerges halfway through that validation phase? Just how flexible can the scales of justice be when the facts suddenly shift under everyone's feet? I want you to keep that in mind as you reflect on today's concepts. Thank you so much for studying with me today. Namaste.